Okay, thanks, Simon, for the introduction. And I also want to sort of thank Hans for the invite to take part in this series on decolonising democratic innovations and deliberative democracy. Some of you may remember I was a participant, or I attended the summer school back in 2020 here at UC before the whole world went crazy and we had COVID and we basically couldn't meet in person for 2 years. And so I think this is my first physical visit back to the University of Canberra since that time. So yeah, as Simon said, I'm discussing native title, which is the focus of my PhD research. And I'm drawing on, I guess, a lot of what I'm writing about in my PhD. My PhD is very much an empirical approach to this idea of deliberative democracy or deliberation as undertaken by Indigenous people, and I look specifically at this network or this system called the native title system, which I'll get into as I go through.
You can click that, or you should be able to forward with the arrow as well.
Yeah, okay. So first, what I want to do is, as an Aboriginal man, an Aboriginal person here in Australia, one of the things we do whenever we're, I guess, in a formal setting, in an institution, is to acknowledge the country or the traditional owners of the country that we're on.
Apologetically, I failed to. My apologies for that.
Yeah. So I just wanted to start by saying, I acknowledge that we're on the traditional lands of the Ngunnawal and the Ngambri traditional owners. Acknowledgements of country are sometimes, I guess, dismissed as being, simply performative, that they're a bit of political correctness we do at the beginning of a proceeding. But I actually think they're a small act of decolonisation, and I think the fact that we do it in Australia is quite important. And a couple of the quotes I've got up there on that slide about acknowledgement to country. The first one is from a very recent federal court determination, a native title case, in which Justice Rangier, if you can read it, sort of says matter-of-factly that the court is not giving the Waka Waka people anything. It's simply acknowledging that which has always been known, which is that the Waka Waka people, this has always been and will always be your land. And so in Australia, we have this really sort of slightly absurd situation where we have acknowledgements of unceded sovereignty in judicial reasoning. We also have acknowledgements on welcome to country in our national parliament at the beginning of each parliamentary year. Yet we don't have self-determination, we don't have recognition of sovereignty, and we have very limited forms of Indigenous self-government in Australia, despite, as the second quote says, despite the presence of Indigenous society being recognised in our courts. So in terms of what I plan to do today, so this is just an overview of my presentation. So I'll start with an overview of Mabo, the decision that introduced native title to Australia. I'm mindful that perhaps a lot of people in Australia and perhaps overseas aren't necessarily understanding of what native title is. So I'll do a very rapid overview of native title. And then I want to talk about four, I guess, what I see as democratic innovations or democratic practices within the native title system. And this is around agreement making, the native title network as a public policy network, an example of participatory governance, and this idea of Indigenous nation rebuilding within the native title system. And because we're talking about decolonisation, I've just got a fairly famous quote by settler-colonialism scholar Patrick Wolfe outlining what he thought decolonisation is or was. And so, as he says, it's premised on this logic of elimination. So eliminating, I guess, evidence of Indigenous ways of being, of governance, of knowledge, of language. And then the last bit is probably the bit I want everyone to keep in mind when we're talking about decolonisation, is that, as he says, invasion, which we can also term as colonisation, is a structure rather than an event. So we're not talking about, decolonising something or colonisation, sorry, as something that occurred on the 26th of January in 1788, and then its effects, let's say, dissipated shortly thereafter. But it's something that builds upon itself and ends up being a structure around Indigenous people. So colonisation in Australia, this is a painting of Captain James Cook, who so-called discovered Australia in 1770. The important bit in this is that in Cook's diaries and everything that's written about colonisation of Australia, engaging with Indigenous people, it's an historical fact. That the British colonisers encountered Indigenous people and Indigenous societies when they arrived here in Australia. But from the perspective of colonisation, the British treated Australia as terra nullius, as a land belonging to no one or not being occupied by people that they could relate to in, I guess, a political sense. And the term terra nullius is fairly complex. I won't go into it about when it did or did not become sort of official policy around colonising Australia, but pretty much up until 1992, Australia was, colonisation in Australia was explained upon this idea of terra nullius, that there were no societies that the British could do legal and political treaties with. So what they missed, of course, was all the Indigenous nations that were in existence at the time of colonisation. And so this is an indicative map. A lot of these nations no longer perhaps exist, or they've merged into others. And I guess the effects of colonisation have wiped out a lot of this, diversity amongst Aboriginal Australia. But the map's really powerful, I guess, in terms of showing just how many nations there were, and really in terms of what we're talking about these days, a lot of these groups still see themselves as sovereign people, and a lot of the political struggles that Aboriginal people have in Australia is getting the state to recognise these nations as still sovereign people on unceded lands. So quickly, what is native title? I can't go into great detail, but it revolves around a High Court decision in 1992 that found that an Indigenous group in the Torres Strait Island still retained their rights in land despite the assertion of sovereignty from the British. It's quite unique in that it's one of the few legal rights that Aboriginal people possess. So we don't have a Bill of Rights here in Australia. We don't have constitutional recognition. We tried it, but it sort of ran out of, I guess, government support or Indigenous support as well. And even though we're a signatory to the United Nations Declaration on the Rights of Indigenous People, which demands that states protect self-determination, self-government, we haven't put that into domestic law as well. So native title is one of the few rights, others being perhaps the Racial Discrimination Act and cultural heritage rights, but it's been constructed as a domestic property right rather than a political, cultural, sovereign right. So it recognises rights in land, but it doesn't recognise a right to self-government. And so native title has many flaws, which I've put an asterisk there, I won't go into, but there's lots. But what it does offer, I think, is a hidden, invisible, underappreciated, and potentially rich space for studying Indigenous modes of deliberation. And here I've cited a paper by one of your colleagues, Roger Davis, who published a paper last year where he talked about the sort of hidden or invisible aspect of Indigenous deliberation, particularly within the field of the sphere of environmental management. So very quickly, native title covers a vast amount of Australia. So all the green bits are where native title has been determined. So you can see Aboriginal people, have an interest in a large area of land in Australia. As a procedure, native title begins as litigation. So it's a legal case that starts off as a claim. It's then determined by a court. And then the area that I'm most interested in is this third bit about management. And so the quote that I've got up there is that, once native title has been achieved, it then becomes a management problem and involves an unstructured but complex network of Anglo-Australian rules and regulations. And so this complex network looks a little bit like this. So in systemic terms, there's a core which is around the role of the courts and the parliament in sort of regulating the Native Title Act and statutory bodies involved in native title. There's also a really expansive policy and planning sphere where you've got government departments, engaging with Aboriginal groups around native title and interests in land. And then you've got an Indigenous sphere where you've got groups undertaking nation rebuilding, self-determination, rebuilding traditional governance, and then looking at, opportunities around community and economic development. And then outside of the formal system, you've got civil society interests that look to support Indigenous groups using their native title. And then you've got private interests, mostly mining and agricultural companies that want to use Indigenous land. So having described native title as a bit of a system, one of the things I did look at earlier in my PhD was doing a deliberative systems analysis of native title. And even in the scope of a PhD, that proved to be really, really complex and something I might look at doing post my PhD. But a lot of my thinking has been really informed by political theorists who really tried to understand this problem of how do states recognise and accommodate, Indigenous, not only land interests, but these political and legal interests that we assert as well. And so two political theorists that have really sort of informed my thinking are Duncan Iverson, who poses the question in one of his books, can liberal states accommodate Indigenous peoples? And the other is Philip Pettit, who talks about democracy or talks about minority groups, including Indigenous people, needing a contestatory mechanism to be included in a model of democracy. So Pettit doesn't actually use the term deliberative democracy, but I think if you read this article, you can see he's alluding to something quite deliberative. He's talking about a mechanism, a richer two-dimensional conception of democracy with, deliberation at the heart of that. And so this idea of a contestatory mechanism is really what I'm doing when I'm looking at native title and the native title system. I'm looking at how do Indigenous people contest issues around self-determination, self-government, sovereignty within the native title system. And contesting these issues back to the state, because the native title system, or native title, sorry, sets up a lot of engagement between either government or government agencies. This, contestation plays out in courts, in the public, in the policy and planning sphere as well. So in terms of talking about, democratic innovations, thinking of the native title system then as a contestatory mechanism, I've identified what I think are sort of four forms of this contestation, and four forms that I think are quite innovative and deliberative practices by Aboriginal and Torres Strait Islander people. Because of the time constraint, I'm probably only going to talk about the last two, but the four things that I think are quite unique to the native title system is the way that Aboriginal people go around agreement making with the state. A lot of agreement making is quite transactional. It's usually somebody wants access to Indigenous lands, we'll pay you an amount of money for access. So it's, we give you money in return for access. Certain agreements now are starting to look what some legal scholars are saying are sort of like treaty-like in how they're agreed to. So there's things like recognising the sovereignty and the political agency of Indigenous people in some of these agreements. The Native Title Network also acts as a large public policy network. So ideas about how relations with the state could be better are often discussed within the native title system. Practical as well as theoretical ideas around what self-determination looks like within Australia are discussed and move around the native title system. And then two things which, I'll discuss now are participatory governance. So how do native title holders work with the government in a collaborative sense on something which I'll discuss around caring for country. And then also this idea of Indigenous nation rebuilding. So if we're talking about self-determination and Indigenous self-government, Indigenous people have realised that they need to start rebuilding their own modes and institutions of traditional governance in order to speak back to the state, I guess, in a nation-to-nation capacity. So caring for country for people that don't know is a unique sort of form of Indigenous environmental management. So it blends, looking after the natural environment, concerns around biodiversity and environmental sustainability. It blends it with Indigenous cultural knowledge, but also Indigenous peoples, Aboriginal peoples' authority over their traditional lands. And so it's fairly unique in that it brings this idea of environmental management together with this idea of Indigenous self-government and having authority over their traditional lands. And so there's a long history behind where caring for country originated it from and where it come today. So its seeds are sort of in the 1970s, but particularly since 2007, the governments at national and sub-national levels have really started to invest in caring for country. So it has this bipartisan sort of support as a great way to achieve environmental outcomes, but support Indigenous self-determination as well. And so caring for country has sort of been picked up by planning professionals. So the book cover I have on the left there is a fairly recent book that was published to help planning professionals be more aware of what I guess Indigenous people's interests in land and how they can better accommodate these ideas of self-determination and Indigenous sovereignty in their profession as planning. The middle book cover is a Indigenous environmental plan. And so this is where you can see these ideals of environmental management blending with Indigenous ideas of self-government, self-determination and sovereignty. And then the third one is just a fairly recent newspaper article that I saw where you can see that environmental management, many Indigenous people see their lack of rights, I guess, in the land, but also in water as a political problem, not just an environmental problem. And so this group is sort of demanding that, the Victorian government here take more notice of their demands around water justice. And then I've got a quote there from a case study undertaken by Timothy Neal and a few others that sort of, I guess, get to this point that, environmental management as undertaken by Indigenous people isn't just a technical practice. It's not just, Indigenous people doing what other environmental managers do. It's actually an experiment in decolonising, because you've got this, this meeting between the traditional role of the state under colonisation of having management responsibility for public lands or the natural environment, meeting Indigenous people's assertion that this is our traditional country and we actually have authority over this land. And so, yeah, so you've got this sort of decolonising engagement happening in the environmental management space. And so just building on that, and where I'm with in terms of my PhD, thanks, is looking at, yeah, the public policy space as really something as not just, you know, rather benign, but this sort of this space for political encounter between Indigenous people and settler states. And that, you know, this rethinking of this you know, this new understanding of the public policy domain has really shifted because of the recognition of native title. And the quote there I've got up there by Agus, you know, talks about this shift in the politics of place in Australia because of the recognition of native title, and that it's created these innovative negotiation spaces, between settler and Indigenous peoples. So in terms of Indigenous nation rebuilding, which is the other part that I'm quite interested in, this is taken from a North American text by an American scholar. North America has been quite, I guess, more progressive in this idea of Indigenous nation rebuilding. And so it's happening here in Australia, but I think the you know, much of the strong work in this is from a practical and theoretical view is in the United States. And so a lot of Indigenous groups have talk about turning away from engaging with the state, and this idea too of this politics of refusal. So rather than engaging with the state, they refuse to engage and turn inwards and start rebuilding their own sort of governance and institutions. And it is happening a little bit here in Australia. So I had a slide.
So we lost your graphic.
Yeah, yeah.
I actually think it comes next. It looks like is it the next? I think it might be the next transition.
Yeah. Okay. Sorry. So yeah. So this is just from a group here in Australia in the far north of Western Australia, who had their native title determined, I think it was about 10 years ago. But you can see in the bit that I've got underlined that for a lot of native title groups, is sort of this regeneration, this renaissance and rebuilding of Indigenous nations is something that's starting to take place here in Australia. And groups see native title, yeah, not as simply a property right, but as something that can drive them towards, you know, a rebuilding of their Indigenous nationhood. Okay, so just to sort of start wrapping up, so the work of decolonising democracy is pretty difficult if you ask Indigenous people. We've been at it for quite a long time, and it's hard work. In terms of you know, this idea of democratic innovation, to be quite honest, the work of decolonising in Australia is really slow and iterative. It's not sudden and rapid. Even after things like the Mabo decision, you know, the way the Australian state is structured and run didn't change, you know, in entirety. And this is where I think this idea of, you know, remembering that colonisation and what we're trying to decolonise is actually a structure and not simply an event. And what compounds this difficulty is that the state actually, you know, resists engaging in a deliberative manner with Indigenous people. And so, you know, the fear is around having this engagement or this deliberation dialogue that doesn't have a simple, neat end, which the state really likes. They like to sort of, you know, have a reconciliation process or have an apology, and then that's it. You know, yeah, let's all move on. And so the possibilities that might come out of a negotiation with Indigenous people, I think, you know, the state quite often isn't keen to engage in that. And so I want to finish then with three, I guess, provocations about this idea of decolonising democratic innovation. And the first couple really came out of a discussion I had with one of my PhD supervisors, so I can't say it's entirely my idea. So Dr. Sana Nakata, as we were discussing this presentation, she asked, like, who, you know, the question that occurred to her was asking who benefits from deliberative democracy, democratic innovation, potentially decolonising? Is it the field and the literature and the scholars associated with it, or is it Indigenous people and our political struggles? The second provocation is that innovation implies an openness to change and developing new understanding. So I guess, you know, one of the questions that stands out is, you know, is that the case with the field? Sometimes these changes can be really problematic for people who've, I guess, been in the field for a long time, and trying to fit other concepts into a field where the concepts are kind of settled can be problematic. So there's an issue around that. And then the last point I make is really that here in Australia, Aboriginal people often talk about people being, or non-Indigenous people being a good ally. So if you're going to support or be part of a political struggle for Indigenous people or colonised people elsewhere, then that, you know, are you prepared to be a good ally? And that means sort of, you know, not seeking to speak out on behalf of Indigenous people, or you know, minimise the efforts of Indigenous people. Our groups, you know, is the discipline or are scholars prepared to listen? One of the values that Indigenous people have, which is quite high in any deliberative exchange, is the ability to listen. I think Bobby Banerjee said at the first presentation that dialogue is the weapon of the powerful. I think it was something along those lines. And so Indigenous people actually value listening over speaking. And so there's a question around, I guess, listening over talking. So look, I know Simon's keen for me to finish up. So they're my three provocations about this idea of decolonising democratic innovation. So I hope it's been interesting, and I'm happy to take questions and have a discussion about my presentation.